Hi everybody and welcome back to our Workplace Compass podcast series. My name's Jess, I'm a legal director and knowledge lawyer in the employment team here at VWV.
And I'm Kiki, I'm a partner in the employment team.
And we are really pleased to be returning to our Workplace Compass podcast series where we share bite-sized updates to help you stay on top of the latest employment law changes in the Employment Rights Act and also beyond. But before we dive in, please do make sure that you like and subscribe to the podcast so you don't miss any future episodes.
Yep, so over the next 4 episodes, we're going to be unpacking the latest updates under the Employment Rights Act 2025, including the key updates, the ongoing consultations, and what this means in practice for employers, HR professionals and managers.
And in today's episode, we are going to just have a little recap on where we got to with the Act since last time and what has changed since our last update. So let's get started.
Yeah, so a great place to begin is with what parts of the Act are now in force. So you may know that only a few changes took effect on Royal Assent and in February, with more changes set to come into force from April.
Yeah, that's right. So the Minimum Service Levels Act was repealed when the Employment Rights Act got Royal Assent, and that was back in December. But that wasn't a huge deal because that Minimum Service Levels Act had hardly been used since it was passed back in 2023. So the fact that it was repealed didn't really have much practical impact for the majority of employers.
Yes, so the first sort of more interesting changes came in 2 months after Royal Assent on the 18th of February, and all these changes relate to trade unions and industrial action. Some of these changes, they might sound a bit dry and technical, but they are significant for employers, and particularly when you look at them all combined. So, for example, industrial action balloting rules were relaxed. The 40% support threshold for important public services was removed, and the notice period for industrial action was shortened from 14 to 10 days.
Yeah, that's right. And as well as all of that, the industrial action ballot mandate was extended from 6 to 12 months, and also some picketing rules were relaxed. So taken together, these changes are intended to simplify the process for unions, essentially, so making it easier and quicker for them to organise industrial action. So that is something that clearly employers are going to need to be aware of, as it's likely to increase the potential for both for trade union recognition and industrial action going forward.
Absolutely. And it means employers might need to be more proactive, essentially, in preparing for that risk. So looking ahead then to the next raft of changes in April, the ability to take paternity leave and unpaid parental leave will both become day one rights, and the current restriction on the ability to take paternity leave following shared parental leave will be removed. And we're also looking at changes to statutory sick pay, which you may have heard about, the removal of the current 3-day waiting period and the removal of the lower earnings limit.
Yeah, and these changes are going to have a big impact on day-to-day HR management for employers. You'll need to update policies, make sure line managers are aware of the latest statutory rights, and HR teams will, of course, need to be well aware of the changes. And as well as all of that, in April, sexual harassment disclosures are going to be given specific protection in whistleblowing law. And there are also going to be some more trade union changes aimed at simplifying the statutory trade union recognition process. So there's actually quite a lot to those changes. So we're going to dig into them some more soon in their own mini-series coming up.
Great. So shall we turn then to the latest updates on the Act?
Yes, so since our last episode, which was around the time of Royal Assent, there's been quite a lot that has happened. So the government has launched a number of consultations, and we're going to look at some of those in more detail later in this series. And also the government has published an updated implementation timeline.
Yes, and probably the most interesting thing in that updated timeline, or certainly for me, was confirmation that the fire and rehire provisions have been pushed back from October 2026 to January 2027. This delay is probably because of the knock-on effect of Royal Assent being much later than the government had originally anticipated.
Yeah, that's right. And as a brief recap, those new fire and rehire provisions are going to make it automatically unfair to dismiss an employee for failing to agree to changes to core contractual terms, which are going to be called restricted variations. And restricted variations will essentially include changes relating to pay, hours, time off, or the introduction of a clause in the contract which allows employers to unilaterally make changes to those terms. So on that last point, and importantly for employers, there's nothing actually stopping you from introducing those so-called variations clauses into contracts now before those fire and rehire changes actually take effect. And that, I think, is something that is really key for employers to be understanding and thinking about now if they aren't already.
Absolutely. And the really important point to note here, I think, is that there's this window of opportunity right now, which will only exist until January 2027 to introduce those clauses if you need to.
Yeah, that's right. And the other thing to mention, I think, in the world of fire and rehire is the consultation that is currently open. So this is an interesting consultation, and looking at it at high level, it can look like an attempt to draw some boundaries around the scope of these new fire and rehire restrictions and how widely they will actually operate in practice. The government in particular now is consulting on whether things should sit outside the scope of what this restricted variation definition will constitute. So, for example, the government is currently minded to exclude expenses and benefits in kind from the scope of what will constitute a restricted variation. And that could potentially include quite significant benefits, including accommodation, meaning that changes to those terms, depending on the consultation outcome, they might not automatically trigger automatic unfair dismissal protection, even though, of course, they could still be challenged under ordinary unfair dismissal law.
Yes, that's right. And the consultation's also looking at whether certain types of shift pattern changes should be brought within scope as restricted variations as well. And I suppose what's interesting about this is that the approach doesn't seem to be based on how big the change is, but the type of change. So, for example, moving someone from day to night work or from weekday to weekend working, that could be caught.
Yeah, and the consultation is clear that if a contract already gives the employer flexibility, so to vary their shift patterns in the way you've just described, Kiki, that flexibility will still be able to be used in the normal way. So these new rules are more so aimed at preventing employers from forcing through changes through dismissal and re-engagement, rather than from stopping them making changes that are already permitted under the contract. So the contract of employment becomes more important than ever before in terms of looking at it and determining the nature and extent of changes that you are entitled to make.
Yeah, so January 2027 is going to be a busy month, I think, for employers, because not only the fire and rehire provisions, there's also the reduced qualifying period for unfair dismissal and the removal of the statutory cap on compensatory awards, which are also going to come into effect.
That's right. So this means that we're actually already in a period where the unfair dismissal qualifying period is tapering off. So what that means is a new recruit who starts work on, say, the 1st of April, they will effectively have a 9-month qualifying period because they'll qualify for unfair dismissal protection on the 1st of January because they will have accrued more than 6 months service by then. And then similarly, new starters from July of this year onwards, they're going to have the 6-month qualifying period. So employers need to be thinking now about what that means for their contracts, their probationary period clauses, as well as whether they need to update or introduce new policies such as probationary policy and line manager training to prepare for this change.
Yeah, I mean, I just would want to reiterate that if you don't already have a probationary policy in place, you should really think about introducing that now alongside the line manager training.
Yeah, I agree. And I think probably the last point to mention on the unfair dismissal side of things is the removal of the statutory cap on compensatory awards. This was the big surprise around the time of Royal Assent last year. So as well as ending up with a 6-month qualifying period for unfair dismissal, the government also confirmed that it would be completely removing the statutory cap on unfair dismissal compensatory awards.
Yeah, That's right. So that means from January 2027, claimants would be able to claim potentially unlimited compensation for all unfair dismissal claims, and not just those where there's a discrimination or whistleblowing claim, as is the case currently. So the government so far has said it doesn't think that the removal of the cap is that significant, because few tribunal awards with unfair dismissal reach the maximum cap at the moment. But I think it's safe to say that I think most employment lawyers disagree with that assessment.
Yeah, I think that's right, Kiki. And, I think the consensus seems to be, well, it's one thing to say that the tribunal makes relatively few awards at the top end of the current cap, which is about £118,000. But it's another thing to say that this change is going to have a limited impact. And I think one of the major impacts will be how this is going to change the way that claimants or would-be claimants approach settlement negotiations.
Yeah, I think you're right. And arguments about mitigation of loss could also get quite interesting in claims that end up going all the way to the tribunal. So removing the cap, I think, is likely to have a significant impact on how claims are approached and negotiated.
Absolutely. Yeah, I think you're right, Kiki. And okay, well, that was a lot to cover there, a little whistle-stop tour of everything that's been going on since our last episode. So that brings us to the end of this episode of our Workplace Compass podcast. We hope you found it useful. And just another reminder, please do like and subscribe so that you can make sure that you don't miss any future episodes. So see you next time.
Bye.
Bye.